So, good afternoon, everybody, and welcome. And thank you for joining us for the final installment of our Special Asset Summer School series. That's right, in just 1 hour, summer school will officially be out. This class led today by Thomas Wolfe and Michael Weaver are going to explore the foreclosure in North Carolina and South Carolina, covering the key similarities and differences in process, timelines, notice requirements, and creditor protections between the two states. My name is Haley Cook. I'm a marketing coordinator here at Ward and Smith, and I'll be your moderator this afternoon. If you have any trouble or any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature on your screen, and I'll be happy to troubleshoot with you. As you see, the webinar is being recorded and all attendees are muted with their videos off. You can ask questions during the webinar via the Q&A button. They will probably answer them at the end, but we might answer them during it, just depending on how it goes and how relevant it is to the topic. I did want to just point everybody into the direction of our past webinars section of our website. So in case you just want to relive summer school or in case you want to send it to a friend, you can click this webinars tab right up here. This is on our website, warrensmith.com. Scroll down to past webinars right here, the series. And then at the bottom, this will change after today's over, but you'll be able to see the last two. In addition, I will send this to you at the conclusion, probably tomorrow, actually, the slide deck and the link to these videos. So as I mentioned today, our speakers are Thomas Wolfe from our Raleigh office and Michael Weaver from our Columbia, South Carolina office. They are both creditors' rights attorneys here with us at Ward and Smith. Although this is the last webinar as a part of our summer school series, it is Michael Weaver's first webinar with us, and we are so excited. This is the professional moment you've been waiting for, Michael. I just know it. So welcome, Michael. We're thrilled to have you. I'm going to go ahead and turn it over to Thomas so you guys can listen to the gentlemen that really know what they're talking about.
Yeah, thank you, Haley. Yeah, I can feel everybody's excitement online that this is the last seminar that will be given this summer, or maybe there's a lot of disappointment out there that they can't just keep going. Either way, thank you all for taking the time to be with us here today and listen to what we have to say about foreclosures. I think it surprises a lot of people to know that North Carolina, South Carolina, very close to one another, but worlds apart when it comes to foreclosures in the process and everything else. Um, I will be talking through the lens of the North Carolina foreclosure side. I practice here in North Carolina. It's where I'm licensed. I am in our firm's Raleigh office, although as most of you know, our offices are across the state, and so we cover everything in all 100 counties of North Carolina. And obviously, Michael is going to be handling the other side and talking about South Carolina distinctions and issues that pop up. In its broadest sense, North Carolina, I think, tends to be the oddball in the situation. I think most states have a different type of foreclosure process. Ours is a little bit different because it utilizes a trustee as part of the deed of trust, who is a neutral third party that's involved. They're meant to be the kind of facilitator of the foreclosure process itself. That's the first big issue. That's a matter of statute that's built right into all deeds of trust. That's why we don't have mortgages, which are the same type of document without that third party. These are proceedings are heard by a clerk of the court and not by the judge. That's another big difference that we see. It allows ours to be a bit more of a procedural process rather than a contested judicial process. That also tends to make it possibly on some occasions to be quicker. Again, 30 to 90 days to secure an order and move towards sale is what we generally see although that timeline can vary wildly depending on if there's issues with service or someone appears and wants continuances or has some sort of defense they want to raise. Michael in South Carolina.
Thank you, Thomas, and thank you, Haley, and thank each of you for taking time out of your day to talk about foreclosures. It's not often that people get excited to hear what creditors' rights lawyers have to say. It's kind of like having to talk to a funeral director or a nursing home administrator. It's not something you really want to have to do, but when you need to, you want to make sure you know who you can talk to and who you can trust. So I'm grateful for having this opportunity. As Haley said, it is my first summer school or summer or special asset summer school session. It's frankly my first summer school period in my life. I spent 4 decades trying to stay out of summer school, and that streak ended today with each of you. But excited to have this opportunity to share a little bit about what I know about the South Carolina foreclosure process. And I will note, in addition to it being 2,000 degrees outside here in Columbia, South Carolina today, I was excited to have a chance to wear a tie. But I grew up and was raised about 5 minutes from where Thomas is sitting today, right outside Raleigh. And notwithstanding the fact that there's so many commonalities between our two states here in the Carolinas, and even in a lot of areas of the law, this specific area with respect to foreclosures is very different. So we want to take that time today to sort of highlight what some of those differences are, and you'll see similarities too. What Thomas just described about how things work in North Carolina sounds like a dream. The timeline specifically, that's a lot slower here in South Carolina. It is a judicial foreclosure state. As many of you know, or your team members know, you have clients, customers that have real property in both states and do deals in both states. So maybe you were aware of it already, but we have a judicial foreclosure state. We don't have deeds of trust. We have mortgages. So we've got to get to a judge and get before a judge to get a deed, a foreclosure deed. And that process, even if it's uncontested, typically takes about, I tell clients usually about 6 months. And again, that's if it's uncontested. And we have to have the matter. We have 46 counties in South Carolina. There's 100 in North Carolina. In the 46 county, even though we have 46 counties, they'll either have masters in equity or special referees that will hear these foreclosure cases. And we have 23 designated masters in equity. So that means there's 23 counties in which they don't have them. I don't really have a good explanation for you why we don't have them. I just know statutorily, if you have a county with less than 130,000 people in them, you can't have a master in equity. So, but typically in the counties with the higher populations, you'll know exactly which judge you're going to be in front of, and you have to have the foreclosure case referred over to him or her. The, Other than who pays the master in equity or the special referee, they're very, very similar. They each have the ability to enter findings of fact, conclusions of law, enter the foreclosure orders, etc. Their orders can be appealed to the Court of Appeals equally. So that process is all similar, but you have to know exactly who you're going to be in front of, and that depends on which county you're in. So it's very county specific. And those are just a few highlights of some of the differences. And we're now going to talk to you about some aspects of the foreclosure process that is very similar in whether you're dealing with a North Carolina loan or a South Carolina loan. And honestly, it all starts. I love the due diligence part. Thomas and I will get a phone call. We'll get a load of documents, and the first thing we want to do is review them to make sure that they all say and do the things that your credit team thought they said and they did, to make sure that we can move forward with the foreclosure. And if we are, we're going to go make sure that there actually, has been a default. We need to understand the type of default that has occurred. And we have to understand the notice, if any, that is required. Um, if it's a payment default, those typically will get, 5, 10 day notices. If it's hey, you failed to pay your insurance or you failed to pay your taxes, those typically in the loan documents that I've seen those require 30 days notice. So we'll do that to make sure that we can properly get the notice out, and that there won't be any issues on the back end if they say they didn't get anything. One specific thing I look at this stage of the game here in South Carolina is whether or not has been an appraisal rights waiver. In South Carolina, if it's a non-consumer case, it's not involving a dwelling, borrowers can waive their appraisal rights, and appraisal rights give a borrower who a deficiency is being sought against the opportunity to ask for an appraisal to have that appraised value, if it comes in higher, substituted for the high bid at the foreclosure sale, such that the deficiency amount against them is reduced. There's a statute in South Carolina that specifies exactly what you have to say, and these are typically found in mortgages, about providing the borrower with notice of their waiver. It's usually in all caps, bolded, underlined. Um, but it has to be on the same page as the borrower's, or in this case, the mortgagor's signature. It's not uncommon for people to think that's included, and it is included, but I've seen many times where that provision isn't on the signature page, and thus that creates some enforceability issues. And that's something you want to be aware of, and your lawyer wants to be able to make sure he or she can tell you about on the front end so there aren't any surprises later. Then, of course, we do our standard, bankruptcy and military search. We want to make sure there's no automatic stay issues if we were to pursue anyone who's in bankruptcy. We also make sure that they're not an active duty service member, and if they are, then there's a path we pursue for that. Title search is critical, whether you're in North Carolina or South Carolina. This gives you the chance to confirm that you are in the position that you assume or believe you are in. It also lets you know who specifically needs to get notice or be named as a defendant in the foreclosure. It also gives you the opportunity to see if there are any defects. And this stage of the game, you always want to identify the issues to the extent you can, because you have the opportunity potentially to fix them. And so if you go through in the title search and you see that there's maybe a defect between the language in the mortgage versus the vesting deed, it gives you an opportunity to fix that either before filing the lawsuit, or maybe asking for reformation of the mortgage as a separate cause of action in the complaint. So make sure you do, a thorough title search. Tax liens, we just wanted to note, and Thomas had indicated that in North Carolina, those need to be paid before the deed is recorded. And then in South Carolina, the main thing I wanted to make sure everybody knew, because I'm not aware of what the North Carolina tax notice and time period is. In South Carolina, real property taxes become a lien on the property on January 1st of the year. However, the bill for those taxes typically don't go out they're not sent out by the counties until October timeframe, and they're not due until January 15th of the following year. And then if those are not paid by January 15th, then additional penalties start getting assessed. If the taxes with the penalties are not paid prior to usually around the first week of November of that year, there will be a tax sale, and the property will be sold at the tax sale. And of course, the borrower and any mortgagee should be getting notice of that and the opportunity to pay those taxes. If for whatever reason the property is sold at tax sale, then the owner and the mortgagee, here the lender, would have up to 1 year to redeem it. So typically, with the lenders that we deal with, we want to make sure, we want to know whether or not the taxes have been paid, and that we have a plan in place to address them before it goes to tax sale. And then we know in South Carolina, if the property was somehow sold at tax sale, we have 1 year to remedy that issue. And the last thing we wanted to just note here, and Thomas may have had some different experiences with it, but we want to know whether or not what the collateral is. And obviously, banks sort of, that your customer, you kind of know what you're dealing with, and should have a good idea of the environmental issues that might be there. But knowing whether or not there's anticipated environmental issues will help dictate how you deal with the borrower, and how aggressive you are with the borrower, or how accommodating you might be to the extent that you can um, resolve it in negotiations with the borrower. All right, let's go to the next slide, Haley. And Thomas, why don't you tell them about how it starts in North Carolina? And I should have noted at the beginning, Thomas and I tried to highlight some of the North Carolina and South Carolina features. North Carolina it's in what I used to call, Carolina blue. Once I moved to South Carolina, I realized that when they reference Carolina, they mean South Carolina. So I'll refer to that as Carolina blue. But in the South Carolina specific things are highlighted with like a garnet color.
Well, thanks, Michael. Yeah, I didn't go to UNC, but I'll accept having the Carolina blue throughout for now. Um, yeah, one last thing on the tax liens I did want to add, because it comes up sometimes in North Carolina, it's worth noting that the winning bidder is who has to pay those tax liens before the deed's recorded. And I think that's important because I've had um, lenders who want to proceed with a foreclosure and have prepaid those taxes before we get involved in the foreclosure or during it. And that's not typically the best way to do it because it's the winning bidder's obligation to pay those at the end. And so if you pay them ahead of time, yes, you can recoup those costs as part of the foreclosure, but sometimes it's easier to just push it off and let somebody else handle it and incur those costs at the after the fact. So just quick little distinction to note there. Um, but as Michael pointed out, this is kind of the next stage of the due diligence, right? We've already taken a look at everything. We're comfortable that we have the right to foreclose. We've got all our parties named. And so now we've got a couple of things that need to be done before we can actually trigger that proceeding in North Carolina. Um, there's a series of letters that need to go out that have strict language that needs to be included to check the boxes on the statute to start things. So the first thing we do is, we send out our formal demand letters, right? We got to review the loan documents, see if there's a right to cure in there that we need to address first. If that has to be done, then we'll get that clock started right away. If not, the idea is to immediately demand payment, accelerate the balance owing on the note, and the most important part, trigger a right for attorney's fees to be recovered. In North Carolina, contractual right does allow you to recover attorney's fees, but it's not enforceable in the proceeding until you provide strict notice, providing them 5 days to pay the entire balance in full before you can recover them. And there's magic language that has to be included in that letter. It has to mirror what the statute says. I have been practicing and doing creditors' rights really for 17 years, and I don't think I've ever seen anybody pay the balance in the 5 days since the letter's mailed. Usually they're not getting the letter in the mail until 3 or 4 days after. So it's really just a matter of checking the box and sending that out. And then once it's done, now you can recover those attorney's fees and it's fully enforceable. We also want to note that if there's any assignment of rents, go ahead and send out the letter to trigger that right as well. Although it's not usually the most helpful letter to send when your borrower is also the tenant or it's one of their other companies that kind of work hand in hand. You just never know how things are run or if it's a third party that's actually in place that's not connected to the business. So we want to send out an assignment of rents letter to put them on notice that there is a problem and that they should not be making any payments to their landlord, which would be the bank's borrower. Those payments should come to the bank instead. That's important because if they do pay over that notice, it opens them up to liability from the bank, and now it gives you an extra party on the hook that we can then pursue for the amount of any payments paid over that notice. And while you're sending out those letters, it just doesn't hurt to just put that in a pile, send it out, and kind of preserve that right to recover later on. And the third one is a pre-foreclosure letter. Another statutory requirement has to be sent 30 days before a hearing to provide kind of that one last opportunity to the borrower, let them know that we're getting ready to file a foreclosure, to provide certain information about different agencies they can contact to try to negotiate a resolution, or without having to go through the foreclosure. Again, has very strict language that needs to be included to trace back to the statute. But again, just something to put out there, get another updated payoff, and check that box. Once all that's done, you're in position to file the foreclosure. But as I said before, North Carolina utilizes a trustee. While our office does handle the foreclosure, we review everything, we prepare documents, and we represent the lender in a foreclosure. It's not our action. The trustee is the one that has the power to file it. They're in the deed of trust as holding the right to proceed with the foreclosure. And normally, as you know, when the deed of trust executed, there is an LLC or a company or somebody else that's been nominated as a trustee, who is not usually going to be the party that files the foreclosure action. We work with different trustees across the state. And so what we want to do is substitute in a new trustee that we work with to help run that process. So you're not beholden to the original trustee in your deed of trust that was executed 20 years ago. We just use somebody that is a trusted partner, that will stay independent of our office and allows us to kind of run the foreclosure with them, operating the filing, and they will go to the hearing and all that. So we got to swap them in. It's through a simple substitution that's recorded with the Register of Deeds office, puts the world on notice that they're in the case, and then we can proceed from there. And so once that's done, you've got all your pre-foreclosure stuff out of the way, and now it's time to start foreclosure. And you can go to the next slide, please, Haley. So in North Carolina, again, it's a non-judicial process. It's before the clerk, and it's very administrative. It's a matter of filing the appropriate documents, submitting an affidavit, and getting before the clerk with a hearing. But the whole goal is to get an order from the clerk that says the deed of trust says what it says, and that we're entitled to foreclose, and we can proceed with the sale. And that's it in a nutshell. It's a very straightforward process. But there are some details to be aware of in North Carolina. The first is the notice of hearing, which is the operative document that opens up the proceeding. And at that point, we've already scheduled a hearing before the clerk. And the notice is simply that, hey, borrower, here's the date that is about 30 days out that we're going to be holding a hearing to see whether or not the bank is entitled to foreclose. It has to be served on all parties in interest. So anybody that is on the loan, guarantors, anybody that owns an interest in the property, present or future interest, you're going to want to include on there, because as their rights being affected, they're entitled to appear and contest the foreclosure if they so choose. Now, we don't serve that notice on junior lien holders. Yes, they have an interest, but their interest will be done away with at the foreclosure sale. So we tend to notice those parties later on. We want more people participating in the sale to try to generate interest and sell the property at for a high enough value to get paid in full. And those junior lien holders may want to protect their interests later on, but we don't need to and don't necessarily want them involved in the hearing. It's not the part where we want more parties involved. We want it straightforward and only the minimal parties involved. So that hearing will go before the clerk. All the documents are submitted to the clerk beforehand, so they'll have a copy of the loan file. They're gonna take a look at all those service member affidavits and everything else. They're going to review that deed of trust to look for, as you can see, the elements of the foreclosure listed there. That's, 6 specific items that they're looking to see if they've been satisfied. And if they are comfortable that the bank is the holder of the debt, there's a default that the deed of trust provides for foreclosure as a remedy, and proper notice has been provided, and that there's no statutory protections about this being some sort of a home loan or active duty status in the military, the clerk is usually satisfied. Most times, if you go in there and it's uncontested, it's a matter of just a conversation with the clerk. It's pretty informal. Some courthouses have a dedicated kind of a mini trial room where it's on the record and you can sit there and listen to the opposition if there is any. Some courthouses, you just sit literally in the clerk's office in a chair and go through this process. So it's very informal sometimes. And most of the time, the clerk is prepared by reading all this ahead of time and already knows whether or not the order is going to be entered. It's a matter of whether or not the defendant is coming with any sort of evidence to contest this foreclosure, and those things can be addressed there in the room. If there is a contested foreclosure, the trustee again stays independent. That's why it's important that not only they appear at that hearing, but we also appear for the lender as well. So there's always somebody there to look out for the lender's interest. The trustee arguably is pursuing the foreclosure on behalf of the lender, but it's important to note that they don't represent the lender, and so they will not push one position over the other. They will take a neutral position about what the code, what the statute says, and whether or not the foreclosure is warranted in this situation. So after that, it's a matter of getting the order entered. It gets served on all the parties in interest afterwards, and then we can proceed with setting up the actual foreclosure sale itself. That notice, as I mentioned before, will be served out on all parties that we identify that are interested in this property, including junior lien holders. Again, we want to generate interest in the sale. We want more people there to try to sell it. So number one, the bank isn't the one that's buying the property back. If we can get someone else to buy it for a sufficient price, then that works better for everybody involved. The problem with the publication part of serving out the notice of sale, it has to be served on all the parties, typically by sheriff or registered mail. You can post it on the location itself, but it has to be published in a local newspaper. And I know it's outdated. It doesn't make any sense. I wish it would be different, because I've seen bills in the past year that varies county to county. I've seen the cheapest ones around $1,500 to post in the newspaper. And I've seen one in the past year that is over $5,000 to post. And so it's a significant cost. And sometimes that hearing is continued, or it needs to be reset, or there's a defaulting bidder. And so it needs to be republished later on. And then the cost gets duplicated. And so it's a very expensive part of the process. Unfortunately, the statute has not caught up with modern times and still requires that it get posted in the newspaper, and that cost stays the same if it's online, which is the part that really boggles me. But either way, and the last part, just want to mention a third-party auction company. It's something that we can consider in most cases if it makes sense. Usually if it's a specialized piece of property, commercial property, and we know that there is a designated market for that property out there, we can definitely engage with a third-party auction company to help generate interest, post notices, handle the auction, and with all the bells and whistles that entails to try to generate interest. It's a great way to do it, but you got to be very careful, because the foreclosure sale is a statutory process, and you got to make sure that it follows in line with that. And that means that you can't charge any additional fees and credits to the purchaser for the auction company. It would be a contract between the bank and the auction company, and it would have to be paid for outside and separate from this process. So again, if that's a consideration, just talk very closely with your attorney to make sure that any contract that's entered into and the terms of that are very clear, so we don't inadvertently violate the statute. All right, we can go on to the next slide from there.
Thank Thanks, Thomas. I think I'll step in here and just to help the group understand the way Thomas and I have set this up is to sort of follow the process by state. So like initiating the foreclosure, the foreclosure, the due diligence, initiating the foreclosure process, the foreclosure sale, and the sort of post-closing items. And we're kind of doing it as we go in each state so you can kind of understand, as opposed to us just presenting how it's done in one state and then um, exclusively talking about how it's done in another state. And I'll just note that Thomas just covered everything that you have to do to get up to the foreclosure sale in North Carolina, and he accomplished it in 2 slides. So I'm jealous. It's going to take me a little bit longer, but it's somewhat similar. But at first, we got to file Liz Pendon's summons and a complaint. We got to initiate that lawsuit. And again, that's after you've already done all your due diligence. You know who you're naming as defendants. You know who the junior lien creditors are. Um, and I wanted to note with respect to the Liz Pendens, that document, it's Latin, it means the lawsuit pending, but it's designed to put the world on notice that there is an issue with title to the specific property, such that any person that acquires an interest in the property from the date and the minute that Liz Pendens is filed takes subject to the outcome of the litigation. The Liz Pendens can be filed in South Carolina up to 20 days prior to the summons and complaint. So it can be filed before you actually file the lawsuit. But it has to be filed up to, I think it's 20 days before the actual um, order of foreclosure is entered. So I've only seen it done usually either 20 days beforehand or it's filed contemporaneously with the summons and complaint. But again, it's a statutory requirement and it puts the world on notice that, hey, there's something going on with this piece of property. In addition, we file our summons. It's nothing unlike, I guess, what you would see in litigation in North Carolina. We do typically include additional provisions notifying the defendant they have, in addition to notifying the defendant they have 30 days to answer. If there's an assignment of rents provision, there's specific language that we include in our summons to let them know that we have a lien on the rent and that they should be turned over to us, and we'll be asking the court for relief with respect to it. And then we also include that language in there about having the case referred over to the master in equity or special referee, depending on which county you're in. So I just wanted to note that for you. And next, we'll go to the next slide here, Haley. Um, so in the complaint, it looked very similar to what some of the information that's included in North Carolina. You file the lawsuit in the county in which the property is located. Um, you have to make sure you've got know where the defendants reside. You have to include the date of the default. You have to include, the amount that's due, the applicable interest, and you need to include your request for attorney's fees. I will note that South Carolina, I don't think is as finicky with the entitlement to attorney's fees as North Carolina is. I know Thomas indicated you have to include that language in the demand letter and give them at least 5 days to pay it before you can assess those attorney's fees. That's not required here. But our complaints also, importantly, you want to have the court determine what the amount of the debt is, that you want any sort of junior liens extinguished, and that you're asking that the property be sold at foreclosure sale. In addition, the last document that we typically would file right at the outset is the certificate of exemption from the alternative dispute resolution requirements. In South Carolina, most litigation has to be, you have to mediate or somehow go to alternative dispute resolution before you can go and have the issue determined. There are some statutorily exempted legal matters that don't have to be mediated, and mortgage foreclosures is one of them. And there's a specific form that we file indicating that we don't have to do ADR on that. All right, next, now that we've filed the complaint, the summons and the complaint, and we've waited at least 30 days to determine whether or not the defendants answer, regardless of whether they answer or not. Typically, what we would do is seek to have the case referred over to, referred over to the master in equity or the special referee. And the way that is done is you can either do it through consent if you reach out to the borrower and they'll agree to doing it, or their attorney and they'll agree to do it, which typically happens. If they don't, you can file a motion. The court can look at what's in your pleadings and determine whether or not it's appropriate to have the matter referred over. But once it's over with the master, then it's kind of subject to their own that specific judge's calendar. So you can usually get things scheduled and heard a little bit sooner than if you were to remain over at the trial, the circuit court level. And if they're if it is uncontested, you'll file your defaults and then have it referred over. And then you'll ask the court to schedule a foreclosure hearing, and you have to provide notice to all the defendants of the hearing. And one thing I wanted to note here is make sure, because the court ultimately is going to need to have a record of what is heard at the foreclosure hearing. So you want to make sure that you're going to have a court reporter there. And a lot of masters in equity in South Carolina don't have, or not all of them at least, don't have their own staffed court reporter. So you may want to just inquire with the court to make sure that you bring or arrange to have someone there to record the proceedings if you want. And then if it's a special referee, special referees are typically lawyers, full-time lawyers who on the side do these special referee matters. So they have their own practice. They do not have a court reporter on staff. So you can, count on having to arrange to have a court reporter for any proceedings in front of a special referee. All right, next slide. So once you get to the hearing, this is, well, whether it's contested or not, you're ultimately going to want to make sure you show up and present executed copies of the note, the mortgage, any assignment of rents, show that you provided notice of the hearing. You'll want to have an affidavit of debt from the client verifying that the debt is owed, and also an affidavit from your lawyer detailing the attorney's fees and costs that have been incurred. And then subsequently, the court will be looking to you or the lawyer to submit a proposed order, judgment that will have that record, that will have indication of all the documents that were presented, the amount that's required, all the loan history, the defaults, and that sort of thing. And then you'll also want to get a notice of sale prepared. And just like Thomas indicated in North Carolina, you have to notice the sale out and you have to publish it. Same requirement in South Carolina. In South Carolina, the notice of sale has to be published in a newspaper of general circulation in that county for 3 consecutive weeks and before the sale. It's harder to find what those newspapers are these days because there's fewer of them. But it's a statutorily required step. And let's go to the next slide. Okay. And now we're at the foreclosure sale. And Thomas, why don't you tell them how that works in North Carolina?
Yeah, so now we're finally to that part where the rubber meets the road, right? Everything we've done before is all preparatory. All we're trying to do is get that order and judgment that allows us to sell the property. And it's just that, it's an auction. It's an auction that takes place on the courthouse steps. It's open to the public. And so, again, North Carolina is a creature of statute when it comes to this. So it's a very detailed, strict process on how it moves forward. But who can bid? Well, the bank, obviously, or the lender can submit a credit bid, which means you can make a bid up into, what you're owed on the loan without having to pay any money out of pocket, right? If anybody else shows up, a third party bidder, and wants to submit a bid, they're going to have to put down a deposit, and that deposit is the greater of $750 or 5% of the winning bid amount. And obviously, most cases we're talking about 5%. 750 is not a whole lot of money if you're foreclosing. So again, if there's a high bidder that's not the lender, they've got to put down a deposit that's going to sit with the trustee until the sale closes. If you're the bank and you don't exceed what you're owed on the loan, which you want to be careful not to do, you don't have to come out of pocket. What you're doing is essentially setting the minimum bid auction amount by bidding, whatever it is you're owed or the value of the property. Depends on how you discuss with your attorney on bidding strategy. Um, the borrower can also bid at the sale, right? They have every opportunity to buy back the property. They can redeem and pay off the loan, plus all attorney's fees and costs to the bank to stop the foreclosure at any time before it's final. Alternatively, they can go to the sale and bid. So if the bank does not want to submit a credit bid, arguably the borrower could come back and submit a bid for whatever they want to buy back the property. They might have to deal with a deficiency later, but it's certainly an opportunity for them to get it back for less than the full amount. Again, there's a deposit that's required if anybody else buys the property. If they don't pay that deposit, then you need to offer up for sale again. And so we got to be careful with the trustee and how these auctions are handled. We want to make sure any winning bidder is there and has the ability to pay a deposit. I mean, most people don't come with certified funds in their hand. The more serious bidders that are used to buying foreclosure property typically come with several checks in hand so they can submit them right after they have the winning bid and the auction closes. Sometimes people need to run to the bank to get their check, which is fine, but sometimes that doesn't happen. Sometimes they don't come back, or sometimes they can't get the money that day. And that's problematic because by statute, the sale needs to be done over again, which means you then need to republish the sale again, which is more cost. So it's a problem that happens from time to time. Once the bid is in, once the deposit's there, a report of that sale will get filed at the same time with the clerk and start the upset bid period. In North Carolina, there is 10 days for other parties to come in and place an upset bid on the property and then become the winning bidder. That just restarts it for another 10 days. And this process goes on until no more upset bids are received in 10 days, and then it finally closes. So the caveat there is that an upset bid has to be 5% more than the last bid amount. So if the winning bid is $100, that next bid needs to be at a bare minimum $105, and so on and so forth. So if someone really wants to win the property for the best price, you can go to the auction and bid $1 more than the prior bidder to win the property. If you wait till the upset bid period, which a lot of people do, you tend to have to pay a little bit more because there's a minimum threshold to submit that upset bid to avoid these processes going on for an extended period of time. Again, I mentioned you can work with a third-party auctioneer. Just need to be careful that nothing in that contract and nothing that's done will violate the statutory procedure, which would create bigger problems. It's an added expense, but if it can help generate more interest, sometimes it's worth the hassle. All right. So I want to talk a little bit about the limitations on the auction process because there's a lot of pitfalls to avoid. You got to adhere to that statutory process. You can't avoid proper service, notice, reporting requirements, any of those things. No online bidding. This is a process that takes place in a particular place at a particular time. It's posted, it gets posted in the courthouse so the public can see and be able to participate. It happens right on the courthouse steps in most cases. You can't do anything to restrict the public's ability to bid on the property. So you can't you can't require bidders to register for an auction. You can't have them pre-qualify, anything like that. And that's some of the stuff that auction companies will try to do. They'll try to get information beforehand to try to control the sale a little bit more. And we got to be very assertive, make sure that does not happen. They also sometimes want premiums on property, or extra costs to be included to pay for their fees, and that's also not permitted. You know, it's a public auction. It's sold as is at wherever, with all faults, and it needs to be done without added costs or hidden fees to the public. So it means the bank also cannot set a reserve or a minimum price to the auction. Again, we can't force people to pay more than they have to, but again, the bank can submit a credit bid. While most lenders don't want to be the winning bidder and end up with the property, this is the only opportunity they have to set a minimum price by protecting their interest in the loan amount by submitting a credit bid, which is, you know, usually there's a bidding strategy is discussed between the attorney and the bank to figure out what that bid should be. It's got to be weighed with a number of factors, you know, depending on the loan amount, the value of the property, what would be an appropriate price to get fair value, to avoid further defenses. And also, it's got to be high enough to protect the bank's investment, but also you want it low enough to generate interest for the public that they feel they can, there's enough meat on the bone to submit their own winning bid. Sometimes if there's even a little bit that's cut off there, it works for the better because then the bank can avoid those post-closing fees and costs and hassle of taking back property and marketing it and selling it. So there's no hard and fast way to do it. It's a conversation, and there's a lot of factors that need to be looked at there. Um, as for the location, again, number one thing is look at the deed of trust. Sometimes that will alter where the process takes place. It's rare, but sometimes there's provisions in there about where it can be done. Absent any sort of provision, it's going to be held on the courthouse steps. You know, sometimes the deed of trust say you can hold it on the premises, but that's usually again for, you know, different types of collateral that's very specialized, where it makes sense to have the public come out, inspect the property, um, understand a little bit more about what they're buying. Sometimes it's more convenient if you're going to have a large auction. You know, I've done a foreclosure sale where, the lender was selling a golf course in the community. So there's a lot of interest. And once the sale was held, it was inside the courthouses where they required it to be held. And it was a very jammed little spot. Sometimes having the ability to move it somewhere else might be better for the public, especially when the public is very interested and you're going to get a lot of onlookers there. So it can be a little more convenient to avoid busy courthouses and parking issues. Of course, the con to that is, you know, there's liability concerns. You know, you don't want people walking around property that's not really the bank's yet. You don't want liability issues if people were get injured, if it's some sort of commercial property where there's, you know, moving equipment and things like that. And so it's again one of those things that you need to balance what makes sense for that particular situation. All right, so the sale happens, the bid is put in, you got a winning bidder, and so now we need to report it to the court. Again, procedural. We got to file the appropriate notices with the court. Once the bid closes, the proceeds are paid over to the trustee. You know, the winning bidder needs to pay the rest minus their deposit that was already held before. Once that's done, the trustee is going to deliver the trustee's deed. And file what's called a final report with the clerk of court. Essentially, the final report is going to lay out all of the proceeds that were received and all of the payments that were made by the bank. You know, the loan obligation, the real estate taxes, the costs of doing business to get to where we are. And it's just a simple balance sheet where the clerk's going to look at it and audit and make sure all of the money collected went out to the items that we're saying they went to. We got to submit that with all sorts of receipts and other proofs of payment, and the clerk's going to take a look at it. Once it's approved, they'll sign off on it. And that essentially finishes up the foreclosure itself. So now we've got a winning bidder, we've got a clerk that approved the process, and so then again, the trustee is going to deliver the deed to the winning bidder. Hopefully that's someone else, because then they can take on the cost of the taxes, but also title insurance. You know, if the lender is the high bidder, you're going to want to get title insurance. So that's where it's going to come down to having some good title work done at the beginning that you can rely on. Going to need to rerun that title work, submit it to the insurer, and ensure that you got title insurance. And in addition, property insurance. If the lender is the high bidder, you want to make sure you're covered for the period of time between when you purchased it and are marketing it and selling it to others. And again, now I will turn it back over to Michael to talk a little bit about what that sale process looks on the South Carolina side of things.
Thanks, Thomas. And in looking at the two and thinking about the two, the back end of the foreclosure sale process in South Carolina, I think is substantially similar to North Carolina. But let's take a minute and talk about the differences on the front end of the foreclosure sale. It is held on the courthouse steps. That's similar to what Thomas just described in North Carolina. And it is conducted by the master in equity or the referee or one of their designees. But importantly, you're going to want to make sure that you have a thorough discussion and that your lawyer has a thorough understanding of what it is the bidding instructions are. And here's sort of where we get a little bit different. And when we file our lawsuit several slides ago, we would normally indicate whether or not deficiency is demanded or not to preserve that right. Typically, we would demand it. You have the ability to waive that right up at any point up until the foreclosure hearing. If the deficiency is waived, then you as a foreclosing lender have the ability, you would enter a minimum bid and you have the ability to bid more than once up until the point where you either have the property or you're content with the price and letting it go at that. The sale would, if that in that instance would be final at the conclusion of the falling of the gavel, at the conclusion of the sale. It's not subject to any upset bids subsequently. If you do demand deficiency, there's a couple of important things to note. The lender only gets to submit one bid, one credit bid. So in that instance, the foreclosing lender typically would submit a bid at least as high as the appraised value of the property. So it's important to have some sense of what the value of the property is. And then the sale will be open for another 30 days. Nothing happens 30 days. The sale it comes back open and anyone can submit a higher bid. And after that point, it gets the sale is final. I know in North Carolina, Thomas indicated that you wait 10 days and someone can submit an upset bid and then we'll wait another 10 days until there's no more upset bid. So this is a distinct difference between the two processes. Just like in North Carolina, a 5% deposit is required on the day of sale. Typically, the balance would be due within 30 days from that point. All right, Haley, let's go to the next one. Now, this gets back a little bit in strategy with respect to the commission that the selling officer is entitled to. They get a 1% commission. And, if you're credit bidding, the higher your credit bid would dictate, a higher amount of commission that might be required. So in some instances, if you haven't demanded a deficiency, you're going to want to not pay any more in commission than you absolutely have to. And the other thing to note is, in South Carolina, although there's no requirement that a minimum bid, what the minimum bid must be, generally the courts, particularly if a deficiency is demanded, would require that the bid not shock the conscience in order to approve the sale. So that's just one thing. And there's not like a firm guidance as far as like what that amount is, but the cases indicate that at least 10% of the property's value would be required for it not to shock the conscience. In all sales, it is, buyer beware. So they'll have to do their own due diligence. And as far as like the post-sale documents that you're going to be filing with the court, sounds very, very similar to what Thomas described. You're going to provide a report of the sale and the disbursements, how much was collected and who got paid what. You'll prepare and submit the foreclosure deed. And then ultimately the case moves towards, closure with an order closing the case, and you'll file any satisfactions that you need to with respect to the mortgage, but also a satisfaction of that lis pendens document that we talked about earlier. And then there's no right of redemption of the borrower for the borrower after a judicial sale, and so you're you're done at that point. And speaking of getting done, we got about 5 minutes left and a couple more slides. Thomas, you want to see if we can wrap those up?
Yeah, I can probably run through these post-closing issues and do like a lightning round here. I did see a question I did want to at least address while we're here, and it's pertinent. I saw a question about the auction amount. If it exceeds the loan amount and the legal fees and everything else, where do, in North Carolina, they're called the surplus proceeds. Where do they go? In short, if there's excess proceeds, presumably the bank has been paid in full, and so someone else, the next lien holder in line, is entitled to get paid those proceeds. The good news is we don't need to determine who that is. We will take the proceeds, that check goes to the clerk of court who will hold it, and it is up to any party in interest that thinks they're entitled to them to then bring another action, and file a complaint and assert evidence and submit their title work to show that they're entitled to those fees, those surplus proceeds. And if no one else objects or the clerk agrees, they will cut a check to them. So it requires a separate lawsuit, which is problematic when it's the bank that's entitled to proceeds on someone else's foreclosure. But that's how it's done in North Carolina generally.
And Thomas, let me just chime in from the South Carolina perspective. Somewhat similar, except the notice would go out to any, junior creditors, and they would have a right to file something with the court requesting that they, receive the surplus funds. To the extent nobody does, and then ultimately they would go back to the borrower.
Mhm. Yep, that's exactly right. All right, so I'm going to run through some of these post-closing things really fast. I know we're tight on time. Um, these items here, personal property evictions, just something to be aware of. Again, very detailed statutory process of removing personal property in the location and evicting tenants. This is a bigger concern with residential stuff where there's a lot more detail on how things need to be done away with. Commercial setting, it's a little more forgiving. Again, just consult with your attorney about what those processes look like. But in a nutshell, there's certain letters and notices that need to be mailed to certain parties, providing certain amounts of time before you can dispose of and just toss personal property away. Likewise with evictions, it can be done as part of the foreclosure process. You can seek an order through the foreclosure file itself to have a tenant evicted and have the sheriff serve that order. So you don't need to file a separate eviction action. It can be done on the tail end, make it a little bit simpler. But the bigger issue is always the deficiency balances. There are defenses available to borrowers out there to be aware of that you just need to be cognizant of going into the lawsuit in the first place. The um, the first is North Carolina's anti-deficiency statute. In essence, the bank is prohibited from seeking a deficiency judgment in certain situations. Number one, if the loan was foreclosed on in front of the clerk and it's a seller financed transaction, meaning the bank seller financed the property to begin with. The borrower can then avoid a deficiency judgment. In other words, you got your property back that you intended to, and so you're not allowed to get any more. And the other situation is if the loan was made to an individual for personal household purposes and it secures that borrower's residence, they can use the anti-deficiency statute to avoid it. Again, most of this discussion is talking about commercial foreclosure, so this isn't really a primary concern, but it's something to be aware of because sometimes you get those legacy loans that are not your normal cup of tea, and you got a residential foreclosure to worry about. Just put it on the back of your mind that there are defenses available. Essentially, what the statute allows them to do is assert this defense to avoid having a judgment entered for any deficiency if there was any of these protected situations. The second defense, I'm sorry, these are on the next slide, Haley. The next defense is the fair value defense, which is very similar. It provides an ability to avoid deficiencies when essentially the bank undercut the bid at the sale, or at least they allege it's been done that way. They can bring forth evidence and show that the property is worth more than the debt at the time of the sale. And if the bid was substantially less, which is a vague term that's used, substantially less than the fair market value, they can use that to offset any deficiency that's being sought. So that one's a little bit more problematic. But again, proper planning, when you're going over bidding strategy to make sure you're bidding enough to cover the debt, but not, you don't want to be too high because you don't want to be paying a surplus that goes back to the borrower. And you don't want to be too low to give them the opportunity to assert this defense. So it's a careful balance that needs to be taken into account. And as I said before, it's very fact specific and it's going to depend heavily on each particular situation. So not a hard and fast rule there. There's no real definition of what substantially less is according to the law. It's going to be one of those things that you know it when you see it, or at least a judge does. So just two things to keep on the back of your mind as part of the planning process. And also these defenses can be used by not only the borrower, but extends to guarantors as well. So just
Yeah.
keep that in mind.
And just as that notes on the slides, those are unique North Carolina defenses, not applicable at all in South Carolina. The closest thing we have to the fair value defense would be the appraisal rights provision that we discussed earlier.
That's right. Well, I think we did it. I think we came in just a little bit over time and don't really have any time for any more questions, but certainly if anybody has anything that they're thinking of that didn't ask a question here, or a question pops up in your mind later on, don't hesitate to reach out to either myself or Michael. We'll be happy to connect a little bit more offline and go over whatever questions you have. Thank you. Haley, I think you're muted.
I'm muted. Thank you. Thank you guys so much. And thank you for all those that attended today. Just as a reminder, I will send out the slides as well as a link to our recording. Please be on the lookout for our announcement of our series for next summer if we don't do anything in between. Maybe Michael is really eager to keep doing it again. We are so grateful for your participation and hope you can utilize this knowledge you've gained today. We extend our thanks, and that is going to conclude today's webinar. Have a great afternoon, everybody.
Thank you, everyone.
Thank you.